Patent myths that can cost an entrepreneur lakhs of rupees. In this video, I will bust all your myths actually. First myth, always entrepreneurs think that patent is a slow process. Yes, it was a slow process actually. It used to take around 5-10 years earlier because Indian Patent Office was not that effective. The people were less. There were very few examiners and controllers, and that was the reason it was a lengthy process. Now there are thousands of examiners sitting in the patent office, and there are also various options like expedite route, which are given to the MSMEs, startups, female applicants, okay, institutes. They can utilize this route by paying additional fees, choosing expert examination, and possibly getting the final result within a year's time. So first myth, the patent is lengthy process. No, now it is not. Even US has this expedite route available. If you have funds, you can definitely opt for that expedite route by paying extra amount to the US PTO. You can get your patent application granted in 1 year. That is what they claim. In India, they claim that within 6 months, they will give you an examination report. So, most possibly, if we are very much optimistic, the patent application may be granted within 7 months. Very optimistically. Otherwise, just keep in mind that 1.5 years is anyways required to get a certificate. If at all you are not qualifying in this route, if you are a normal, natural person, a male applicant, and you're a big company who is not a small entity or MSME, in that case still it will take 2 or 2.5 years of time. Okay, so this is a timeline that is required. So if you think that it's lengthy process, yes, but how companies have been utilizing it, because this was a lengthy process earlier also. Now the government has come up with this expedite route. Earlier, these expedite routes were not available, not only in India, but also in US. These were not available. General timeline was 2 to 3 years of time to get a certificate or get the final results. If you're a startup, I can understand you have a rush to get a grant for a patent. But if you're an established company, MSME, MNC, in that case, expedite route is not required for you, I guess. Let the business, you don't need an expedite route. Generally, what you can do is you should invent at least 3 to 4 years ahead in time. 2 to 3 years is required to manufacture and launch a product in the market, to do marketing, to validate your invention and then launch the product in the market. So 2 to 3 years is an optimistic time which any industry requires to fine tune their product and then launch the product in the market. That will also give you an advantage whether you want to still get a grant for a patent or you want to remove it and move on with the next invention that you have come up with. So this is also good that you will save 50% of your investment that will be used in prosecuting these inventions, right? So generally you can use this time effectively if you are capable of. Don't haste and get a grant early unless and until you are a startup. Otherwise it is not required, I can say. That will give you ample amount of breathing time to make various strategies around it. But still, only 3 years time is required minimum to get us final results for your patent application. Do you think it is more? No, it's not. If you consider manufacturing industry, it's not actually. Thousands of patents are filed by many companies across the globe and they are utilizing this breathing time very effectively. Why not you? This should not be the reason that you don't file a patent application. If you don't file a patent application, you are already losing on your market share because you will see competitors doing the same thing and you don't have anything else in spite of you being the one who has created this idea. Do you want to end up in that particular situation? I don't think so. You should do it. So file a patent application which is must because that is the only tool that can give you 100% monopoly. There is no other tool that can give you 100% monopoly. Am I correct? Every invention can be copied if it is not protected. There are more intelligent people sitting out there watching what is there, what people are doing. And if you don't have restrictions on such copycats, think about where your business can go and what your market share will remain in future. Okay, so this delays can be utilized effectively. Next is patenting is only for big companies. MSMEs don't need these patents. Startups don't need these patents because we don't have money. Think about it again. If you don't have patents, if you're launching new products, how long you can survive in the market? 2 to 3 years? Good. Is that what you're looking for? Good. If not, if you want to stay in the business with the same product, improvement, bring on the improvements, still prevent others from using your old products for 20 years, don't you think that patenting is must? Because how generally product evolve when an innovative product is launched in the market? It's priced at a very higher cost. As it is priced at a higher cost, no one will enter. It's obvious. Okay. Once 2-3 years are passed, when you move ahead in an innovation, you start launching new products. What happens to your old technology? There are competitors who try to bring in that technology in the market with lesser cost. So those patents will help you in preventing those competitions also who are following you behind you for 20 years. Think over it. If you don't think this is important, if you still think that patents are not for you, I doubt how will you thrive in this competitive industry with your innovation and innovative technology. Think over it. Don't think like I want to just give it to the society free of cost. Make your big heart. I know you have a big heart. That think about your business, think about your employees who have joined your company because they have a lot of aspirations and they thought that you can met their aspirations. By giving out to the society, definitely you will get a name. But that's not, anyways, even if you patent it, still you will get a name. Still people can use it after 20 years. Why not you get the benefit from it at the initial stages and then give it to the public later on, right? Otherwise, even you will not have funds to invest further on your researches, right? Think about it. If you're innovating and public is copying your invention, what motivation you will have to come up with new inventions? I think so. I will not have any motivation. But I don't know how you think about it. But at least if I can answer from my perspective, if I'm bringing out something new, which is innovative and which can be patented, in my case, it's not possible. But if something is patentable and it's patented for which gives me protection for 20 years, yes, definitely I will use it. Think about it and define the strategy. Next myth is, once your product is successful in the market, then you can file a patent application. This is the worst strategy I can say. According to the patent law across the globe, if you're selling your product, even a single product, that will destroy novelty because you are exchanging that product, giving all the knowledge of that particular product to the public in exchange of money. You yourself are destroyer of the novelty. In rarest case, you can file a patent application. Sometimes the examiners may not find that kind of invoices. Examiners may not find those invoices that you have raised. In that case, you may get a grant somehow. But if you try to enforce or stop someone else from using these patents, and if they are able to retrieve those invoices, then they can revoke your patent application. Okay, so you have to test rigorously inside your premises only whether your invention is really worth or not. You can give it as a test product with NDA, non-disclosure agreements, to any company, validate the product, whether it is useful or not, sign a non-competent, non-disclosure agreements. If it is successful, then go and file a patent application. But don't sell it. And once everyone is liking your product and then think about filing a patent application. No. Till the time you think about filing a patent application, there is always a competitor that is watching you. And maybe because you have seen some competitors copying your invention, you are thinking about filing a patent now. Is it right? No. Patent law does not allow this kind of patents. It will be always a mess for you. You have to think for the next innovations now. Okay. So publication, selling, you should not do before filing a patent application. So I hope you don't do these kind of mistakes if your invention is novel and patentable, because that can give you millions of dollars if you're able to use it logically, right? If you need any assistance in filing a patent application, building a strong strategy, building a strong patent portfolio where you can dominate your industry, you can contact us. We can definitely help you in building that strategy and a portfolio, and help you in building a portfolio which is strong, which will help you in thrive in this competition. Keep inventing, keep investing, and keep earning tremendously. All the best. Thank you.